Mr. Pass or Mr. Davis, can you reach out to Ms. Daniels and check on her ETA?
Yes.
All right. All right, we'll hold for the court reporter, everyone.
Miss Daniels is logging on now.
Ms. Daniels, are you ready? Ms. Daniels?
Thank you, Judge Jacobs. Good morning.
Good morning. Are you ready?
Yes, sir, I'm ready.
Okay, all right, sounds good. All right, Diamond, let's go ahead and call the calendar. Diamond Boykins,
That will be a bond hearing, Judge.
okay. Arthur Creechy,
That will be a bond hearing.
okay. Rodney Green,
Judge, I'm not sure if anyone on your staff has talked with you about that case yet, but Mr. Green is represented by Isaiah Gregory, and he has filed a leave of absence until the 13th.
That is correct. And the state and Mr. Green's attorney are currently in negotiations.
until the 13th. Well, I guess that means July 18th. July 18th. Jail calendar. He's still, I mean, okay. July 18th jail calendar. Right, and that's 3 cases.
Yes,
The
for
motion- Yeah, there's 4 cases.
4 cases, sorry. Okay, Fatima Leva Reyes,
We'll be requesting a bench warrant recall in that case.
Tabitha Perry,
That will be a bond hearing.
Angela Phillips, 1, 2, 3, 4 cases.
That will be a bond hearing, Judge, but just on one case. She's only being held on one case. She does have other open cases, though.
Which one is it?
If you'd give me just a moment, I would let you know. It's not one of the C numbers. It is the one ending in 618. And I don't see that on the calendar.
618.
Oh,
It's here.
it's an 11.
All right, so do these other cases have future court dates? The C numbers?
I can check on that as well. It looks like one of her cases is set for arraignment on September 25th. That is the number 9.
All right, well, let's set both both of the C numbers, position 9 and position 12 for that same arraignment calendar. Mr. Pass? Mr. Pass?
Yes, Judge, I'm doing that.
Okay, sounds good. So what is the give me that date one more time, just so I can put it on my calendar here.
I have 9/25 at 9:30 a.m.
All right, let's start at the top. Diamond Boy, and we'll get to the bench warrant recalls shortly. Diamond Boykins.
Yes, Judge. Ms. Boykins has been in custody for 15 days. She's charged with 1 count of criminal trespass, and her bond is currently $1,000. Judge, you might remember Ms. Boykins was in front of you not too long ago on a separate and unrelated criminal trespass charge. She was criminal trespass from McDonald's, and your bond order instructed her to stay away from McDonald's. The criminal trespass that she's in custody for now, of note, is not at McDonald's. It is at what appears to be a private residence. And I do not have any information on who the individual is in relation to Ms. Boykins. That being said, I am going to be requesting an unsecured judicial release. While she does have at least the 2 pending cases, she does not appear to have any violent criminal history from what I can see. She has an ACT team with Grady. They provide her mental health treatment, medication, and housing. She does have all of those resources available to her right now. She was previously staying at the Serenity House, which is a halfway house. She is no longer staying there, but she does have a place to stay in Fulton County. We have contact information for her father and her uncle, Eric. She is not working right now, Judge. She receives SSI, but she has previously worked various minimum wage jobs. She does not have any resources to post any type of monetary bond. And that would be my request in this case, an unsecured judicial release.
Your Honor,
What's this?
my apologies, Your Honor, I didn't mean to cut you off. Your Honor, Ms.
Go ahead.
Boykins actually does have a long and violent criminal history going back to 2012. She had a burglary conviction in 2012 in DeKalb Superior Court. 2014, she was charged with burglary in DeKalb County, but pled to an amended charge of criminal trespass and served 12 months. Then in 2018, she was initially charged with murder, first-degree home invasion, aggravated assault, and possession of a weapon during the commission of a felony. She pled guilty to criminal attempt to commit a first-degree home invasion. She was sentenced to 5 years to serve, followed by 5 years on probation. So she is still on probation. She served 3.5 years of that in the Department of Corrections and had a parole violation this past April. The case number on that is 18 CR 4162. This was the murder of Latanya and Birch that happened at the Best Value Inn on Candler Road a few years back. She has 2 other cases pending before this court. The criminal trespass is the oldest criminal trespass occurred on May 25th of this year. She was released on May 27th. Then she was rearrested for the public indecency and the disorderly conduct that happened at the McDonald's on May 30th. So 3 days after she was released, she committed the public indecency and the disorderly conduct. She was released on that case on June 15th. And then the case that's before the court this morning occurred on June 21st. So she clearly does not understand conditions of bond. Currently, her bond is $1,000. With her history, as well as the fact that she has 2 prior cases that are still pending before this court that she has UJR set on, the state would object to any rejection or a UJR. The victim in this case, Larry Brooks, is more or less a stranger. It was an acquaintance. I think the defendant had gotten a ride with somebody and they ended up at his house. And so he had met her, I believe, once. He wants absolutely no contact, and he wants her to not return to the residence if the court sees fit to release her on a UJR, as well as if the court does reduce or give her a UJR, the state would ask that she receive a mental health evaluation within 30 days of release.
I'm trying to go back to 10 Pop Place so I can get my medicine.
Well,
They're trying to put me on anything. I don't trust nobody.
Ms. Boykins, hold on. Judge, Ms. Boykins does not need a mental health evaluation. She has a mental health diagnosis. She has a doctor. She receives medication. She has a full ACT team to assist her. If Your Honor is inclined to make some condition of her bond related to her mental health, she would be able to continue complying with the treatment that she currently gets.
What's the current bond?
$1,000.
Yeah, I mean, but she's now picked up enough. How many pending cases do I have or matter? I mean, there's unaccused. Are any of these cases accused? Let's start there.
I don't believe so, Your Honor. There's 3, including this one, with the oldest just going back to May 25th of this year.
Are they all criminal trespass?
Criminal trespass, and then the second one is public indecency and disorderly conduct, and then this one is criminal trespass as well.
And again, Judge, they are all unrelated. I understand that one of the conditions of her bond is not to violate the laws of any government or institution. However, she has not violated any of the conditions that she not go back to any particular location. So there's no indication that she does not understand the orders of the court or that she will not be able to comply with them.
Yeah, well, I mean, the problem is that, she's picked up 3 different cases in a pretty short period of time, and then has a fairly significant criminal history, and it all may be related to mental health issues, not fairly significant, a significant criminal history. And it all may be related to mental health issues. But I'm concerned that, mere supervision via telephone by pretrial services is not going to get the defendant on the right path. And again, I mean, I've got 3 different cases at this point. I think the $1,000 bond is fair and reasonable under the circumstances. I am not going to reduce it, at least at this time. What I would direct the state to do, though, is to accuse these 3 matters. I mean, they seem like fairly simple cases in terms of the charges involved. Accuse these 3 matters before the next jail calendar, and let's see where we stand then. So I'm going to ask the state to go ahead and get these 3 cases accused. And I mean, if the defendant is inclined to enter a plea, that's totally up to you, the defendant, and consultation with Ms. Obiora. But if she's inclined to enter a plea, to my mind, supervision by probation is going to be much more effective than supervision by pretrial services. But I'd rather see where we are after the cases are accused. So with the history and the 3 matters in front of me, I find the existing bond fair and reasonable under the circumstances, no reduction. All right, Arthur Creechy. So this case should be back in front of me accused next week. And frankly, all of the cases should be on the calendar.
Yes, Judge.
All right.
Judge, Mr. Creasy has been in custody 39 days. This is the first time that he's been on our calendar because this was a municipal court bind over. His bond has only been addressed once, and it was set at $2,000. He cannot make a $2,000 bond. He's charged with 1 count of theft by shoplifting. He does have a history that involves theft by shoplifting. So my understanding is that the state intends to transfer this case to the DA's office. That process does take quite some time, and I am requesting that Mr. Creasy be released on a UJR until his case can be addressed by Superior Court if they do choose to accept his case as a felony. He lives in Atlanta. with a friend. He has 3 adult children. Mr. Creasy's 75 years old. He's lived in Georgia his entire life. He's currently receiving Social Security and retirement. He does not have a lot of financial means. And I understand that he does have a criminal history, but being that it is primarily shoplifting charges, he does not present a danger to the community or even a flight risk for that matter. He does have some health issues, Judge. He has high blood pressure. He has cataracts. He recently had surgery just 2 weeks before he was arrested, which again was almost 40 days ago. He had surgery and was supposed to go back to the doctor for a follow-up and has not been able to do that. So his health is of concern right now. And because the DA transfer process is typically lengthy, and he's already been held for 39 days, I would ask Your Honor to grant a UJR so he can be released while that process takes place.
All right, what's the response?
Your Honor, the state's opposed to any reduction. There had been some issues about the time of the transfer. It also appears that he has some aliases that kind of made things a little difficult in actually determining which case this was. But he has a very long criminal history, it looks like more than 5 theft by shoplifting convictions. So this is a felony based on the number of the convictions that he's had and not on the amount of this current charge, which is property from marshals, about $260 worth. But based on his history that goes back to 2014, the state would be opposed to any reduction, and it will be a DA transfer. So the state feels that the current bond as set is more than fair considering his long history of shoplifting.
And but those are all shoplifting cases, right?
Correct, Your Honor.
All right. My decision is going to be to grant a UJR bond here, or a UJR. Don't violate the laws of any governmental unit or entity. Stay away from the marshals, and report to pretrial services 1 time per week via telephone, and report to court on a future date that I will set if the case is accused in state court. But it sounds like that's not what's going to happen. Mr. Creasy, don't pick up another charge because the outcome will not be the same if that occurs. Understood? You're muted though, the JR. I can't hear the jail anyway.
Thank you.
Oh, there we go. All right, yeah. So, Mr. Creasy, you understand if you come back in front of me with another charge, the outcome will not be UJR.
Yes, sir.
Okay, all right.
And Judge, because there is going to be a DA transfer, would you like me to include any particular language about the returning to court aspect?
No, I mean, in theory, it still can be accused in our court. So, I mean, that's, once it's in the Superior Court's hands, there would be no circumstance where it would be a violation of my bond order. So, so I don't think you need to do that.
Okay.
Okay.
Thank you, sir.
All right, UJR, with those conditions. Again, it's don't violate laws of any governmental unit or entity. Stay away from the marshals with the address in the order. Report to pretrial services 1 time per week via telephone, and report to court on a future date that I will set. All right, Fatima Leva Reyes, do we need, oh, hold on 1 second before we do that. Ms. King, are you available?
Yes, Your Honor.
You're here for an appointed case, right?
Yes, Your Honor. And I believe Officer Cameron and I may have a resolution. So with your permission, if I could go off camera, I can call the jail and speak with Mr. Hooks about resolving the matters today.
All right, can we have Alton Hooks? It's Alton Hooks, right?
Yes, Your Honor. And the jail has sent me the phone number for me to call.
Okay,
Give me one moment. Let me see if he's still down here. He was here earlier for court.
okay, that's fine. We can have him brought down. That way Ms. King can talk with him.
Yes, that's what I'm
Maybe
working
this
on right now.
Sounds good. Thank you.
Thank you, Your Honor.
All right, Fatima Oliva Reyes, is this an interpreted case?
Judge, Mr. Mandujano is going to be handling that. Does she need an interpreter?
I don't believe so. When I spoke with her in
No.
I spoke
Okay,
to-
super. Then Ms. Wallace, I think you can be excused.
Thank you, Your Honor. Have a good day.
All right, you too. Okay, go ahead, Mr. Mandujano.
Judge, so Ms. Reyes was taken into custody because of a bench warrant for failing to appear at arraignment. The address where the notice was sent, following the incident, she had left that address. And so she moved in with with a few family members, and she was moving around. And so in doing that, she forgot to update her address with the court, but she's been living at a home with her partner for over a year. And so we have that address as well as 2 good phone numbers for her. And so I don't see there being any issue in her showing up to future court dates.
Well,
And I can put both the phone numbers and the address into the chat.
yeah, that's fine. If you can put that in the chat, and then Mr. Pass, if you can get those updated.
Yes, Judge.
And then we'll go ahead and set, she missed arraignment.
Yes, Judge, she missed arraignment on September 8th, 2021.
Okay, well, we'll go a full 2 years later. September 27th, 2023, arraignment at 9:30 a.m. We'll need to set up a new session for that, Mr. Pass, but September 27th, and while you're at it, you might as well set up the 1:30 session too. But September 27th, arraignment at 9:30 a.m. September 27th, arraignment, 9:30 a.m.
Your Honor, would the court like me to prepare the bench warrant recall?
I've submitted a recall to Judge already.
Yeah, well, let me see what I got here. Okay. All right. Okay. I just sent the bench warrant recall to Mr. Pass, and looks like the information is in the chat now. So we're all set on this case. Okay. Quintabitha Perry.
I'll be handling that one as well, Judge. And first, before I get into anything, I just want to point out that Ms. Perry was charged with battery family violence, and I just want to make clear that that is not accurate and that this is actually not a family violence case. According to the warrant, Ms. Perry.
Well, who's the alleged victim?
It's actually there was an altercation with an officer where it's alleged that Miss Perry attempted to spit at the officer at the DeKalb jail.
Oh, okay. Well, clearly not battery family violence then. Okay, go ahead.
And so Miss Perry has been in custody for 10 days. Her bond is currently set at $1,000. And she's charged with 1 count of public indecency. And if the battery family violence charge has been updated and fixed, I believe it is now a simple battery harm. And so we're asking for a UJR to be granted today for Ms. Perry. She's lived here in Georgia her entire life. She's living with her friend. She currently does not have a job, but she does have a few places lined up to apply to and to be interviewed for. And those will be more so minimum wage jobs. She also has 3 kids of the ages 12, 10, and 5, and she's very involved with all of them. And Ms. Perry has also been diagnosed with depression. And in terms of treatment, that's just her taking her medications, and she's been very good at being consistent with taking her medications and going to the doctor as needed. And so given that, we believe that a UJR is appropriate so she can continue to get the treatment that she needs to make sure her mental health is good and so that she can be there for her 3 small kids.
All right, what's the state's response?
Your Honor, the state believes that the bond as set is fair and reasonable. In regards to the public indecency, it was around 7:30 p.m. She was in a public place. She took down her pants. She opened up her jacket. She was completely nude. She smelled like alcohol. And in regards to the simple battery, she was spitting in officers. There's 17 cycles in her criminal history. The most recent conviction, Your Honor, is a simple assault. She was sentenced to 12 months probation, and that was in 2019. So the state would reject any reduction or UGR, Your Honor.
All right, my decision here is going to be UJR. Don't violate the laws of any governmental unit or entity. Consume no drugs or alcohol while on bond. Undergo random drug and alcohol screens administered by pretrial services. Report to pretrial services 1 time per week via telephone, and report to court on a future date that I will set. I think that's everything. UJR, don't violate the laws of any governmental unit or entity. Consume no drugs or alcohol while on bond. Random drug and alcohol screens administered by pretrial services. Report to pretrial services 1 time per week via telephone, and report to court on a future date that I will set. That will be my order.
So I do that today. Oh, okay. I don't have to sign anything. Okay.
Angela Phillips.
Judge, Miss Phillips has been in custody 14 days now. Her bond is only $50. There's 4 cases on the calendar, but she's only being held on 1, as we already established. That's position 11. Judge, she is alleged to have trespassed at I believe it's the South DeKalb Mall. The warrant alleges that she was panhandling. She's lived in Georgia her whole life. She's lived at the same residence in Decatur for the past 9 years. She's currently applying for disability and waiting to hear back about that. Unfortunately, at this time, she doesn't have any other income. She does get mental health treatment through Grady, and they also provide housing. I can't be certain, but it sounds a lot like another ACT team to me. being that she does have such a low bond, I believe it's the magistrate court that gave her the $50 bond. Lots of other people would be able to make that. Ms. Phillips is not going to be able to make a $50 bond or any monetary bond for that matter. So I'm requesting an unsecured judicial release.
Response?
Your Honor, the state asks that the $50 bond remain as is. Ms. Phillips has a do not return. She keeps going back to the same shopping center. March 2021, she trespassed at the Dollar Tree, which I believe is right next door. August 2022, trespass again at South DeKalb. June 2023, which is the case at bar, she trespassed again at South DeKalb. February 2023, she trespassed at Rose's Discount. It's all within the same space, around the same area. She has 3 open cases. She doesn't follow rules. In regards to history, there are 23 cycles. There are no criminal convictions within the past 5 years, but she does have a probation violation, Your Honor. In 2008, she was convicted for possession of cocaine. It was out of Gwinnett County. And also in 1995, she was convicted of voluntary manslaughter. The state would reject any reductions or UJR, Your Honor.
Voluntary or involuntary?
Voluntary. 1995, convicted of voluntary manslaughter.
Oh, 1995. All right.
Mhm.
I'm going to grant a UJR bond here with conditions. One of them is to stay away from, it was South DeKalb Mall, right?
Yes, Your Honor.
One of them is to stay away from South DeKalb Mall. Another is to consume no drugs or alcohol while on bond, undergo random drug and alcohol screens, report to pretrial services 1 time per week via telephone, random drug and alcohol screens monitored by pretrial services, report to pretrial services 1 time per week via telephone, report to court on a future date that I will set. And that should be everything. So UJR, don't violate the laws of any governmental unit or entity. Stay away from South DeKalb Mall. Undergo random drug and alcohol screens administered by pretrial services. Consume no drugs or alcohol while on bond. And report to pretrial services 1 time per week via telephone and report to court on a future date that I will set. Ms. Phillips, you understand that if you pick up another charge at South DeKalb Mall, the outcome will not be like this, right?
Sir, I was not at South DeKalb Mall.
No, ma'am, don't argue with me.
I was not at South DeKalb Mall.
Fine. I'll take that at face value. I'm requiring you to not go to South DeKalb Mall. If you pick up a charge at South DeKalb Mall, you understand the outcome will not be a UJR next time, right?
It's like 27 something.
I'm just looking for a yes to my question.
Your Honor, if I may, it's South DeKalb Shopping Center. And
Oh, it's not the mall.
No, it's the shopping center.
Okay. All right. South DeKalb Shopping Center. Why don't we put the address of the shopping center as well in the order of it's South DeKalb Shopping Center. All right, ma'am. It's not South DeKalb Mall. It's South DeKalb Shopping Center. Still, I don't need a response. Just don't go back there. If you pick up another charge, it will not be a UJR next time. Thank you. Okay. Let's be sure we get the location correct in that order, though. All right. Now, couple of walk-in cases. Leonard Murray are to the jail. Are we working on connecting Ms. King?
Ms. King is currently on the line with Mr. Hooks as we speak.
Super, thank you. Leonard Murray? Leonard Murray. All right, that bench warrant will remain in place. It's a 2010 case. Taj Skaggs.
Hi.
All right, ma'am. Looks like you missed arraignment back in 2022. We do have an updated address, correct, Mr. Pass?
I'm sorry, that's my son. You said you have an updated
No, I'm
arrangement?
asking Mr. Pass. Mr. Pass?
If you can please put it in the chat just to verify.
Usually that's difficult for someone on a phone. Can you do that, ma'am?
Yeah, I can put my address in the chat.
Okay, all right.
Thank you.
And it looks like you missed arraignment. So we're gonna, well, she's putting her address in the chat. We'll set the case for September 27th arraignment at 1:30 p.m. in my courtroom. September 27th arraignment, 1:30 p.m. in my courtroom.
Yes, the address is updated.
Super. I don't have a bench warrant recall for this case, though. Do I need one?
Your Honor, I've just prepared one. I'll be happy to send it to the court.
It's in the Remarkable app. Probably have
Which
to
one
refresh.
is it?
It's the first. It should be this last one.
You might need to back out and go back in. It's not populated in here. And these other bench warrant recalls are not anything we need today. Murray, there it is.
Yeah, Murray should be, well, you denied that one because there's a no-show. And then these other two, they need to be processed.
They do? Do we
Yes.
have, do they have future court dates?
Either the case, give me one moment.
All right, here's the Taj Skaggs one. Yabissa and Hagos are in here, but I don't, let's see.
Yes, both cases were reset.
Was this because someone was in custody? They still need to show up to the jail calendar.
No, this was not for the jail calendar, Judge. This was from last week. You just, yeah. These people, they're not in jail.
No, I understand, but they need to come to this calendar in order for me to recall the warrant.
You've recalled it. You just need it to be processed.
Oh, okay. This was from, okay, hold on.
Yes.
I think I just sent you that calendar, actually.
And also in the general folder, you have the bond modification that you also granted last week.
All right, what's is 2020 the date on this Hagos bench warrant? I'm confused. So having failed to appear in court on 6/28/2023. One, 3, 6, 9. All right, wait, Mr. Pass?
Yes, Judge, I see that was an error. That's correct.
Yeah, so don't enter that last one that I just sent you. I'll correct that, but I need to
Okay.
find it. I already deleted it out. What was the case number there?
For Hagos, it is,
No, not the other one, the other one.
it is, give me one moment.
20, I got it. 21C.
01151. My apologies. I see what I did.
That's fine. Going to appear on 9/15. All right, I'm just now sending you the version you should enter. Wait, hold on. Don't enter that one either.
Does what I will do, because I have the original, I can just send it and I can just resend it and
No,
therefore
don't worry about it. It's fine.
Okay.
So here, one more time. Third time's the charm. Go ahead and enter the one I just sent.
Okay, thank you.
Okay, and then All right. And then what'd you say was in the criminal general folder? Mr. Pass?
Apologies. So you granted a bond modification. So that just has to be signed.
Is that Andre Brown?
That is for Clifford Jackson. It should be the first page in. Uh, 22C03072.
Let me just confirm this. So Ms. Obiora?
Yes, Judge, that's my motion.
Yeah, and so we did discuss this at calendar call. That was quite a big calendar call.
Yes, Judge, I discussed that with ASG Abrahami, who's no longer with the solicitor's office. And she did consent to that bond modification after speaking with the alleged victim.
All right, so did we address this in open court or no?
I believe we did, Judge. We didn't address it to the extent that we asked Your Honor to grant that motion, but I believe, if I remember correctly, I noted that we had discussed that.
All right, is there anyone, so from the state, does anyone have any opposition to this at this point?
Your Honor,
State
that would be
versus-
my case.
Okay,
Now, if it was Miss Abrahami's case. So, no, we don't have any objection to that at this point. I've known Miss Obiora long enough to know that she's not gonna make a representation like that unless it's a true one. So
weren't you both over there in Division 6?
we were, Your Honor. I'm following Miss Obiora.
Okay. Okay, well, I've signed an order then converting the no contact to a no violent contact. In that case.
And the last thing, the bond orders were uploaded as well.
All right, well, let me hear from Ms. King. Ms. King?
Thank you for allowing me to speak with Mr. Hooks at the jail, Your Honor. It's my understanding in speaking to Officer Cameron that the recommendation from Officer Cameron and probation would be to revoke 90 days and to close the case out. Mr. Hooks has been in custody since April 8th of 2023, which would be 88 days today, 90 days on Friday. I've asked because I do believe Mr. Hooks has a bond in felony court, which was the basis for the revocation, that we give him credit for time served and close the case out today so that there is no hold outside of him just making bond in the felony case. And that would resolve, it's my understanding, also case number 20C02030, as that was running concurrently with the current case 22C03111. And so
I can't hear you though.
I'm sorry. Is that
Go ahead.
okay?
Go ahead, Ms. King.
The probation
I can hear you
only had
now.
a case under 22C03111
now.
because the 22C case was running concurrently. So it would close out both cases, but Officer Cameron only has a file on the 3111 case, if that makes sense. Sorry, I got a little thrown off.
All right, so do I have a petition in this case, Officer Cameron?
Yes, sir. I sent that.
Can you send it to Jaquan to get uploaded in the Remarkable?
I sent it to him on the 30th.
Mr. Pass?
Yes, I'm uploading that right now.
Okay. Just put that on the front page of the Remarkable, not in a folder.
Okay, Judge. And it's all set.
All right, you gotta back out and go back in though.
Yes, I just did.
Okay. Give it a minute. Still not there. There it is. Okay. All right, there's that. So, Officer Cameron, raise your right hand. Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
State your name.
Officer Brittany Cameron.
All right. Wait, where'd Miss King go? There she is. Ms. King, do you stipulate to a violation of the terms of probation at some level?
Yes.
All right, then I will find that there has been a violation of the terms of probation. And as I understand the agreement, it's revoke 90, credit for 88, and close the case. Is that correct?
That's my understanding.
Officer Cameron, is that correct?
Yes.
All right, well, that'll be my decision. Revoke 90 days, credit for 88 days time served, and close the case upon completion of the terms. Or completion of the jail time. So revoke 90, credit for 88, close the case upon completion of the jail time. And Ms. King, you were just appointed in this case, right?
Yes, sir, on Monday afternoon. To be clear, what I think, and we were doing this all electronically, I was asking that he be released today, that we shave off those 2 days so that there is no hold in state court. That is what I talked to Mr. Hooks about over the phone. So I apologize if there was a misunderstanding on my part. Just figured we were splitting hairs over those last 2 days if he's already done the 88. But I don't know if that was Officer Cameron's understanding.
Well, Officer Cameron, what was your understanding?
My understanding was that he will be released on Friday, so he'll be closed. It will close on Friday.
I'm going to do revoke 90, credit for 88, and close the case.
So he's
So
released on Friday.
Well, yes, today is Wednesday, so I believe that would be correct.
Okay. I want to make sure that that's, I guess, okay with Mr. Hooks, since I did misstate that information. I do believe that there is a bond set in the felony case, but I've not been able to speak to the felony attorney on that matter. So I don't know if I can't really do a breakout room. I don't want to put Mr. Hooks in a position to state anything on the record. If I could go on mute and call him really quick just to make sure, or if he's fine sitting till Friday, he can say so. But if there's something other than that, I don't want him saying anything else on the record, if that makes sense.
I mean, you're welcome to talk with him. We can make that happen. What I would say is that I mean, I'm not sure that would have, well, look, I mean, he's not complied with any of the terms of probation. And he's picked up subsequent felony charges. So, I mean, I would be under those circumstances, particularly with 88 days served already, inclined to accept probation's recommendation of 90 days in any event. If you'd like to talk with him about it, why don't we do this? Mr. Hooks, do you want to talk with your lawyer about that? Just yes or no, if we can have the jail on mute. I just need a yes.
To my understanding, you're saying that it's just 2 more days. Then
I am imposing 2 more days. So do you want to talk with your lawyer about, well, I'm imposing 2 more days. I'm revoking 90 days and you get credit for 88. So you have 2 more days to serve. That's all true. And with that, do you want to talk with your lawyer? Yes or no?
No.
Okay. Then that'll be my decision in the case, and I'll just need that order from the clerk's office sent to Mr. Pass to be uploaded into the Remarkable, and we'll take it from there. Ms. King, I'll get an order appointing you in the case entered today that's nunc pro tunc to Monday. So
no problem. Thank you, Your Honor. And I apologize, Mr. Hooks, for my misunderstanding of that. And I appreciate your time, Judge, in helping us resolve that matter.
all right.
I do believe that finishes my business. If there's anything that I can do to help Mr. Pass, just let me know.
It does. You may be excused, Ms. King. So
thank you.
and that actually wraps up the calendar for everyone as well. So we do have 2 arraignments tomorrow. They are rather light calendars. We've got 2 calendar calls on Friday. They are heavy calendars. So just be prepared for all of that, everyone. I will see you tomorrow and Friday. Thank you in the courtroom.